I'll try to make an effort today and share some of my thoughts on how the Supreme Court is basically what is the future or how should be the future of the judiciary in Pakistan. Let me also qualify that every institution makes mistakes, and I'm sure there are a number of mistakes made by my institution too. But let's just forget about that. Let's learn from the mistakes that we've made, and let's move on, you see. I want to talk about the future. I want to talk about new things, innovations, inventiveness, and what we can do. And let's not be chained by the mistakes of the past, you see. And I don't really want to criticize the past or the previous judges. I just want to look at the future, what we can do today. So the roadmap is absolutely clear for us. We need to walk the Constitution, you see, and protect the constitutional boundaries. That is absolutely clear. It is very simple for the judiciary to move forward. Everything is there in the Constitution, and all we need to do is follow the Constitution, and everything falls in place. So any dialogue on the future of Pakistan would be totally incomplete without an independent or a courageous, creative, and smart judiciary. And I want to use those words, you see. We need to be creative. We need to be smart. It can't be a status quo. We've had that for too long. For 75 years, we've been doing nothing. We've never really thought about reforming our institution. There have been no reforms, actually. So I think it's high time that we thought about something more creative, something more smart, something more innovative. And yes, of course, there's no question about being independent. There's no question about integrity, though they are the basic, requirements for any judiciary to be functional. So without protection of the rights of the people of human rights, there can be no democracy or no justification of democracy. So rule of law, human rights are important aspects and constitutional values that the Constitution gives us on which we need to fashion our judiciary. Without fear or favor, affection or ill will, says the oath, that points towards two things: judicial courage and judicial integrity. So what is judicial courage? Means that a judge decides according to the Constitution and he speaks truth to power. I mean, he's not scared as to who appears before him, whose case is he deciding. He should be courageous enough to decide according to the Constitution. Integrity, on the other hand, is not that a judge is not influenced by position, power, color, identity, race, wealth, relationship, or political inclination. Judge needs to be totally apolitical. He can't have any affiliations. And if he does, he must recuse from sitting on the bench. These principles are pretty simple and straightforward. A judge under our Constitution cannot agree to anything undemocratic, to my mind. It would be against his grain if he were to decide anything undemocratic. We've had in the past where we allowed a number of undemocratic things that the state has done, but I fail to understand how a judge cannot possibly sign off on anything undemocratic. It is so ingrained and so embedded in our character as a judge that I could probably break, but I cannot sign a document or a judgment which would be undemocratic. But it's happened in the past. Recently, the Supreme Court came up with a judgment talking about judicial overreach. They said we cannot interfere in policy issues. We need to understand the separation of powers very clearly. We can't just, poke our nose into every matter that the executive is doing or the legislature is doing. We have our own jurisdiction, and we need to be very clear on our jurisdiction. The minute you step out of your jurisdiction and start interfering in policy matters or matters relating to the executive or the legislature, that is called judicial overreach, and you cannot do that. So judges passing orders which are not anchored in law and do not draw their legitimacy from the Constitution unnerve the other branches of the government and shake the very foundations of our democracy. Interference in policy amounts to judicial overreach. Now, this is something that came after, and I'll talk about suo motu in just a while. These judgments have just recently come out, and I'm quite sure just prior to these judgments, there was a huge suo motu world going on, and we're all aware of that, and all sorts of interference that was going on all around us. So perhaps the judiciary or the judges later on realized that that was not on, and we need to sort of remain within our limits. In the recent judgment on rape, which is to relate with the two-finger test, The Supreme Court has very clearly said that two-finger test or the virginity test of the rape victim has no scientific justification, and the alleged immoral character of a rape victim has no relevance under the law in a rape trial. This wasn't the case earlier, and there were two-finger tests going on earlier. Dragging sexual history of the rape survivor into the case by making observations about her body is an affront to the reputation and honor of the rape survivor and offends her right to dignity guaranteed under Article 14 of the Constitution. A woman, whatever her sexual character or reputation, says the court, may be, is entitled to equal protection of law. No one has the license to invade her person or violate her privacy on the ground of her alleged immoral character. We've also come up with, and I will share that with you, but we need to do it at a national level, we've come up with the gender-based violence court, you see. Now that's very important. In a normal court, if a rape victim cannot sit, because if you look at the kind of people in a court, if the several trials are going on at the same time, the court is jam-packed, and just imagine a rape victim sitting there and the lawyer asking all sorts of indecent questions from her. That's what we've changed. We've come up with a gender-based violence court. This one trial takes place at a time. The victim need not be in the courtroom. She could be sitting in the the room next door. Through teleconferencing, she could make a deposition. And since the establishment of GBV court in Pakistan, in Punjab, just one or two courts so far, the more cases have started coming in, and the conviction rate has also gone up because people can now start attending to this. Then moving on, we've also now looked at science. You see, science is very important. Science needs to come to the courtroom. We can't just say no to science and technology. So recently, the Supreme Court has really talked about DNA as a gold standard test, as a forensic test in cases of rape, in cases of murder, which was earlier not so, and we were not going in that direction. But we brought that in because a judge must enjoy a good sense and understanding of science. As science grows, so do techniques and tools of forensic science, and we need to understand science. Therefore, courts must be open to developments in forensic science and embrace new techniques to resolve a dispute, provided the said techniques are well established in the scientific community. Recent judgment, which talks about adaptive jurisprudence coming out of Pakistan, saying we need to start protecting our country against any possible damage that climate change can do, and we need to take steps accordingly. So in dubio pro natura, environmental legal personhood has now for the first time been recognized by the Supreme Court, and I'll read that. And climate change, climate justice, and water justice are also concepts which our jurisprudence is now talking about, which is pretty cutting edge to my mind. So robust democracies, and I quote from the judgment, robust democracies need to be climate democracies in order to save the world and our further generations from being colonized at the hands of climate change. We've also talked about academic freedom recently, that we're not supposed to interfere in how universities are to be run, what curriculum they need to have, what is their internal disciplinary process. Supreme Court has nothing to do with it, you see. We need to start protecting academic freedom of institutions and protect and honor their autonomy. So in one of the medical college cases, the court held that democracy, human rights, and the rule of law cannot become and remain a reality unless higher education institutions and staff and students enjoy economic freedom and institutional autonomy. Conversely, we cannot have genuine democracy unless the higher education and research community is able to inquire freely. Higher education institutions are places that have to be imbued with democratic culture, and that in turn helps promote democratic values in the wider society. Universities are the playgrounds of democracy, and more freedom and independence they enjoy, the more free thinkers and leaders they will produce. The academic, administrative, and disciplinary autonomy of university must be therefore respected. Coming to suo motu, it has been abused over the years, Article 184(3), and we need to have a serious check on this, absolutely serious. The judge is not a king, or Supreme Court is not a kingdom, you see. We need to be very careful. We are applying the Constitution. I'm bound by the Constitution and the law and have to act in accordance with law like any other institution. Only matters of enforcement of fundamental rights of public importance might invoke suo motu at times, only to promote fundamental rights. suo motu cannot be employed to curb fundamental rights in any manner. We need to have a constitutional amendment to talk about a tenure for a Chief Justice, and a Chief Justice of the Supreme Court cannot be a Chief Justice unless he's been a Chief Justice of the High Court. It is critical that he's had administrative experience and an understanding of administration before he takes over the apex court and looks at the national judicial system. He needs to have that experience. So not everybody should become a Chief Justice. This is something on the internal governance that we need to consider. The elevation to the bench is critical also. We need to make sure, and it's very important, that there is integrity, there is courage, and there's competence, there's diversity. Yes, I fully agree with diversity. I'm very happy that we have a female judge now at the Supreme Court. But that's not as a policy. That's a one-off thing, you see. We need to have a policy. Why can't this happen at the High Court? Why can't this happen at the district courts, you see? Just one-off person elevated to the Supreme Court, very good. I welcome that. But this should have been a part of a big policy. Judicial reforms are important. Now, it's very sad, you see. I don't know if there have been judicial reforms in the real sense in our country. It's been 75 years, and I think we need to sit down and do some serious judicial reforms. And, for example, case management itself is just a basic reform system that we need to do. Bring in technology, bring in artificial intelligence. How are we going to deal with 2 million cases? No clue. Nobody has any idea what to do with it. Case management is an accepted technology, accepted technique all over the world. We need to bring that in. We need to start moving cases. We need to start categorizing cases of children, women, infirm people, old people. They can't just be there. I mean, it's a cliche. In Pakistan, generations go through cases. I mean, one big reform, if that can take place in Pakistan, is that the matter or the list should be decided in a maximum of 1 year from trial court till the Supreme Court, and you're done. And that will revolutionize the country. Nobody talks about district judiciary. Now, this is the saddest part, you see. District judiciary is the frontline courts where the list starts in the original jurisdiction, the magisterial courts and the civil judges of the world. We do not care about them. The system does not cater to them. There's a lack of communication between the tiers and the district judiciary, and it does not perform. It's a very demoralized structure. I think it's very important to have a serious awareness program. We need to have a spokesperson for the judiciary in Pakistan. Everybody talks about their blogs. There are, you keep on hearing all these blogs against or for the judiciary, but there's nothing from the judiciary. There is no spokesperson of the Pakistan judiciary who talks about cases, who tells people what we're doing every day, how many cases we're deciding, and what are the interesting things that we're doing. I mean, I had a chance to go to Brazil, and they have a television station. And they tell about their Supreme Court to the world as what they're doing. So we need to have that, a radio station maybe. We need to get onto Twitter. We need to get onto Facebook, Instagram. Tell the world what we're doing. So whatever little good that we do, that also doesn't come out. So I think we need to do a lot of awareness and see what we can do about it. So on the whole, you see, it's time that we were to restructure the whole thing, revamp the whole thing, and make judiciary and the justice sector more progressive. And lastly, I'll just finish it with a quote or a rubayat from Umar Khayyam, which says, "Ah, love, could thou and I with fate conspire to grasp this sorry scheme of things entire? Would not we shatter it to bits and then remold it nearer to the heart's desire?" Thank you so much.